Imagine being on trial for murder, and the trial judge says you're not allowed to point the finger at alternative suspects. That is exactly what the defense team is saying is happening today in the Delphi Murders case. Hi, I'm Attorney Marc Lopez. I'm an Indiana criminal defense attorney of nearly 20 years, and let's break down what's going on in this case. In the past couple of weeks, there's been two significant rulings on the Delphi Murders case. Number one, on August 28th, the judge said all confessions made by Richard Allen are coming into trial. And then a few days later, on September 4th, the trial judge said, hey, defense team, you are not allowed to talk about any third-party perpetrators. You can't point the finger at anyone else that may have done this crime. The defense team has responded that their entire defense has been gutted less than 40 days from the start of this criminal trial. The defense team wanted to kick out the confessions because they're saying that the confessions were involuntary on the part of Richard Allen. Now, there's a lot into this, but basically the conditions in which he was held were so terrible that basically he lost the ability to do this of his own accord. That's number one. Now, number two, the defense team also wanted to point the fingers at various individuals with ties to Odinism or other paganistic religions and basically say, hey, Richard Allen has no connection to these type of religions, therefore he could not have participated because these murders were done in a ritualistic fashion. They also have some geofencing data that shows people were in and around the crime scene when these murders are said to have occurred. This is a pretty big deal if you're a defense attorney because you get to point at somebody else and say, hey, that's my client, but here's some other evidence. This is powerful stuff. And the judge has completely blocked that and said the confessions are in, third-party perpetrators is out. Now, the defense team has not taken this lying down. They have filed late in the evening on September 9th a motion for interlocutory appeal. What is an interlocutory appeal? Let's break it down a little bit. A normal appeal occurs after a case is over. So there's a verdict, and then the person that lost, presumably the defendant, would say, hey, Court of Appeals, we have a few issues, 1, 2, and 3. Let's figure this stuff out. Now, that's normal appeal. An interlocutory appeal is basically saying, hey, the case isn't over, but we disagree so much with the trial judge's position that we would like the Court of Appeals to review this and give us their opinion before we move forward. So interlocutory appeals are not very popular with the Court of Appeals because, well, the case isn't over. Why would you want to have them do it twice? Interlocutory, and then if someone proceeds to trial, they do it again. So they're not very common, but they do happen. This type of interlocutory appeal is what's called a discretionary interlocutory appeal. And what that really means is the defense team needs to convince the trial judge to sign off on the interlocutory appeal. And that's why you see this 17-page motion for interlocutory appeal, because they're actually trying to actively convince the trial judge to grant them the interlocutory appeal. And if the trial court judge does grant the interlocutory appeal, story's not over. Because it's discretionary, the Court of Appeals also has to sign on the dotted line and grant the interlocutory appeal. So the defense team has to convince the trial judge and the Court of Appeals to take this up on interlocutory appeal. That is an uphill battle. I have asked for interlocutory appeal numerous times as an Indiana criminal defense attorney. I have been successful in getting a trial judge to grant the interlocutory appeal numerous times. I have yet to ever get the Indiana Court of Appeals to accept an interlocutory appeal because, again, they have plenty of their own work to do on final cases. Why would they want to mess around with cases that aren't final? This case, obviously, is a little bit different than some of the cases I've done, and there's a better shot than most for interlocutory appeal to be granted by both the trial judge and the Court of Appeals. So let's talk about that. And you'll see the criminal defense team, it's a 14-page memorandum, and I counted about 75% is talking about the exclusion of third-party perpetrators. About 25% is talking about the confessions. That's kind of where we're at. And the confession stuff, the law is against them. It just is. But as they state in their memorandum or motion, this is a first impression arguing that these living conditions are so terrible to override the free will of Richard Allen. So using those words, first impression, that's a signal to the trial judge and the Court of Appeals, hey, this is important and this is not an established area of law. I don't know how this is going to turn out because the law is against them, but this is a very unique circumstance. Now, the majority of the motion for interlocutory appeal talks about the third-party perpetrators. And essentially, Indiana, you have the right to present a defense. And by saying you're not allowed to point the finger at somebody else, there's no real defense left for the defense team. And you'll see in one of the paragraphs of the motion, the prosecutor is going to object to this interlocutory appeal. Of course the prosecutor is going to object. I've done hundreds of trials, hundreds of suppressions, and I have only had one prosecutor in all those hundreds and hundreds of cases raise their hand and tell the judge, Judge, it looks like Mark's right. Hold on, let's set this out for briefing. One. Of course the prosecutor is going to say how they object. So let's talk about why the defense team argues that the trial judge should grant interlocutory appeal. Number one, basically their defense is gone. Less than 45 days from trial, their defense is gutted. They're saying they have nothing to work with if they kick out all of these things. And so obviously this is going to get appealed if they lose. Every single filing done by the defense team, in my opinion, has been with an eye towards appeal, knowing that this case is going to be appealed, and they don't want a situation where the Court of Appeals says, you should have brought this up to the trial judge's attention. That's why we're seeing so many voluminous things getting filed by the defense team with so many details. They want the record to be very clear that they are bringing things to the attention of the trial judge. So the number one issue, in my opinion, is the fact that this case is basically done if they can't point the fingers at somebody else. Number two, if they have to redo this trial, it's going to be very expensive. They're already transporting jurors, paying juror fees. It's expensive not only in money, but also time, trying to catch up on things. Just redoing the trial is going to be so expensive, whereas if they do the interlocutory appeal now, there would be one less issue to appeal in the event Richard Allen loses that trial. You know, the third reason, in my opinion, is they argue that the world is watching, and basically saying someone's not allowed to defend themselves. Well, that doesn't look too good on the Indiana criminal justice system. So the fact that the world is watching is a reason for the Court of Appeals and the trial judge to grant interlocutory appeal. And the fourth reason is the human cost. These were two little girls, people that loved them, and to make the victims' families have to go through this more than once seems very mean and cruel. So those are the crux of the arguments for the granting interlocutory appeal now, as opposed to making them go to trial and appeal later. Now, the arguments against interlocutory appeal is this case is old. Now, some of this delay is attributable to the defense. Some of the delay is attributable to the judge taking her time on making these rulings. And I'm not criticizing the judge because these are some pretty important rulings she's making. She needed time to research, hear arguments and whatnot. But the case is old, at least for Indiana. Other states move things a little bit slower. Some states move things faster. But Indiana, this case is a little bit old for this type of situation. And then another argument against interlocutory appeal is the trial judge very well might think she's right. I've had judges when I've asked for interlocutory appeal be like, hey, Mark, it's a close call, so I'll give it to you. You can ask the Court of Appeals to see what they want to say. But if this judge truly believes she is doing the right thing, then she might say, I'm going to win anyway. The trial judge in this case is established. She was doing this for a very long time. She's likely seen scenarios similar to this. And if she thinks she's right, she might say, no, let's just keep going on here, and you guys can argue about it later, but I'm right. Even if the trial judge signs off on all this and they submit it to the Court of Appeals, the Court of Appeals can still say no. So, interlocutory appeal is a lot of extra work. And, there's an argument to be made. Do they work on interlocutory appeal or do they focus on the trial? If interlocutory appeal is granted by the trial court judge, inevitably there's going to have to be a continuance of the trial. They can accelerate deadlines and they could say, hey, we're going to keep this trial date, see what the Court of Appeal says. So it's very possible we have the criminal court granting interlocutory appeal, and they say, we're going to keep that trial date to see what the Court of Appeal says, because the Court of Appeals could make a decision in 45 days. In my experience, it takes a lot longer than 45 days for a Court of Appeals to decide an issue like this. But they could see, hey, there is some gravity in getting things done fast. So it's up in the air if there's going to be a continuance. And, if I was the attorney on this case, I would ask for a continuance to pursue the interlocutory appeal if the trial court judge grants it. Trial court judge could say yes, trial court judge could say no. I am dying to see what's going to happen next in this case because there's so many twists and turns. What do you think? If you watch this video this long, like and subscribe, but leave a comment, and I will do my absolute best to respond to each and every comment made on this video. I can't promise, though. That's unrealistic. I have things to do, but I'll do my absolute best. And most importantly, to remember, always plead the fifth.